All right, hello everybody. Why don't we go ahead and get started? My name is Jennifer Kalyuzhny. I'm from the Farmers Legal Action Group in St. Paul, Minnesota. And I just want to thank you all for taking the time to be here on a Wednesday night for this webinar. It's called Using Leases to Meet Financial and Stewardship Goals. So we're just going to talk all about leases tonight and using sustainable practices. So I will just hand it over quickly to Karen Stetler from the Land Stewardship Project, and she will give us a little introduction of how we got to this work. And take it away, Karen.
Thanks, Jennifer. Well, the Land Stewardship Project and Farmers Legal Action Group have had a long history working together. And for those of you who are not familiar with the Land Stewardship Project, we are a private nonprofit membership group in organization in Minnesota. And our mission is promoting an ethic of land stewardship, sustainable communities. We have 3 program areas that are working to lift up that mission, and those 3 program areas include farm beginnings and community-based food systems and policy and organizing. It is with the focus on beginning farmers through the Farm Beginnings program that I came into this work around land access. We had many beginning farmers go to our classes saying that the biggest barrier for them getting started was accessing land. That, coupled with the fact that we had long-time LSP farmer members who were starting to think about next steps for their farm, really led us to think that engaging in this issue, it was the right time to engage in this issue. So about 4 years ago, we started that work. And about 3 years ago, we were fortunate enough to apply for and get a beginning farm and rancher development. Gave us the funds to work with a number of organizations, including FLAG, to develop a toolkit for farm transitions. And so one of the things that was an outcome of that grant and is now on the toolkit or in the toolkit is a piece that FLAG had done, and all about leases and not only meeting finance, but also focusing on what a long-term lease might be. And one of the things that we felt really interested in pursuing with Farmers Legal Action Group around the long-term leases is that for beginning farmers, having that security of being able to access land for a length of time, particularly if people are doing sustainable organic practices, was really key. And so wanted to really devote some time to that. We see that from a landowner perspective, that whole developing a relationship with one operator and also thinking about the stewardship on the land, which goes, for being able to apply for if there are programs, federal programs that people want to apply for. There are some years requirements on those kinds of things. So it's really, we see it as a win-win type of thing. And so last year we were able to not only launch the toolkit, which is on our website and also available through Minnesota Institute for Sustainable Agriculture, if you were interested in a hard copy. But we also had workshops in a couple places in Minnesota, and they were so well attended, questions that were shared, that when we were writing a risk management agency grant this year, we realized that we really wanted to lift up that opportunity for more people to hear about what FLAG had found out, and to be able to ask questions and to just raise it as an option for people to consider. So I just want to share that, and I think it's actually in the presentation, the actual toolkit is available on Land Stewardship Project website, which is www.landstewardshipproject, and then the toolkit is /farm transitions toolkit, how you would be able to access that. So I guess I'm just really excited to be able to be on the webinar with you, and thank you, Jennifer, for sharing all this information.
Thank you for that introduction, Karen. That was very nice. I just wanted to let you all know as well that Eric Sanarud, who started the webinar, he is going to be on the line here, and he'll be moderating for us. So if you have any questions, we'll have some time at the end reserved for questions and answers. But if you have any questions along the way, Eric will be checking the chat box. So if you have any questions, you can just write them in the chat box and send them over, and Eric will read them out loud so everyone can hear them, and then I'll try to get to your questions along the way as well. All right. So I guess we'll just get right into it. So I know we've got a mix today here of beginning farmers and landowners, and I tried to make the presentation tailored for everybody as much as possible. But so I mean, hopefully everybody will get something out of it, all the different perspectives on here. But to start off, we're going to talk about the landowner benefits of leasing. So for a landowner, from their perspective, leasing can provide a reliable revenue stream, and there are also property tax advantages to keeping your land in agriculture. So many states have use value property tax valuations that tax a property based on the value of its current use. So this is normally set at the highest and best use, which would be the land's potential development value normally. However, as a tax incentive to keep agricultural land in production, many states provide that the land's value for property tax purposes will be based on its use for agricultural and forestry purposes instead. So this usually will provide a significant tax savings for the landowner. In Minnesota, the property tax program is called Green Acres for this. So just be sure to check the property tax laws in your state to see if they allow for this tax incentive. Another benefit for landowners, the burden of property maintenance can be shared with the tenant. The landowner has the ability to manage the land in a way that meets his or her stewardship goals. It keeps the land in production when the landowner no longer wants to farm, but they still want the land to be farmed by somebody. And can offer an opportunity to a new farmer or a farm family that's looking to get into farming for the first time. It can also offer flexibility, so it can be a trial period for a farmer who's considering transitioning the land. This is also obviously a key benefit for tenants because it's less of a commitment and less of a financial burden than buying land would be for somebody who's just starting out farming. So it allows tenants to sort of test the waters before they jump right in and become landowners themselves. So some key points to remember, there are a lot of non-legal considerations that go along with leasing that we won't be able to cover in this presentation tonight. So just keep these things in mind, and there are some resources that I'll give you at the end of the presentation that you can follow up with that go into a lot of these non-legal considerations and really help you think those things through. So some of these things would be like financial and stewardship goals assessment, assessment of the land, suitable operations for the land, how to find the right tenant, things like that. So again, there will be a list of resources at the end, and I'll just point you to which ones will be really helpful for you. Successful relationships are built on shared values and good communication, so that's just something to remember in general when you're trying to find a tenant for your land. Communication is just really the most critical thing in all of these, setting up expectations for how the land will be used, and having discussions with between the landowner and the tenant so that everybody's on the same page. Communication is the most important thing. All right, so the basic lease requirements. Leases are governed by state law, not by federal law or local law. So you're going to need to check the state requirements whichever state you're from. Sorry. So I'll talk a little bit occasionally through this presentation about Minnesota because the Farmers Legal Action Group is located in Minnesota, and we are licensed to practice here. So there's just a couple of things that will be specific to Minnesota, but you'll need to check on your state's specific laws for many of these things. But as a general rule, land leases for more than 1 year need to be in writing. That's because of something called the statute of frauds that has been adopted by basically every state. So that's something that will be pretty universal. So land leases specifically that are for more than 1 year need to be in writing. If you have a land lease for more than 1 year that is not in writing, it generally will not be enforced by a court. So land leases that are for 1 year or less, which means 12 months exactly, not a crop year. So just think of it as an actual, like a calendar year. Leases that are for 1 year or less can be valid even if they're not in writing, as long as there's agreement on the basic terms. Even for land leases that are less than 1 year, it's best to try to get the lease in writing. While farmers traditionally like to make agreements on a handshake, written agreements can just be extremely helpful for facilitating a full discussion of the terms and avoiding confusion, especially if a dispute arises in a relationship. So it's even for a short period of time, it's best to have a lease memorializing everything, all the terms you talked about. So just remember, if a lease is required to be in writing, but it's not, it generally will not be enforceable with very few exceptions. Any changes to the lease should also be in writing. Verbal changes to the terms will usually not be enforced. So basic lease terms, these are the things that should be in a lease at the very most basic level to make sure that you have a written lease in place. It can be, obviously, terms can be added in on top of this to get as elaborate as you like, but this is sort of the bare bones. This is what needs to be there. The names of the landlord and tenant, a description of the property to be rented. Ideally, this description would include a map, the address of the property, and if the entire property is not being leased, the specifics of which parcel is going to be the subject of the lease. A legal description can be especially helpful when only part of a lease is, only part of a property is being leased, and also in cases where the lease agreement contains an option to purchase or a right of first refusal clause. In those cases, it's very helpful to have a legal description. So you'll also want to include the rental amount, which can be zero if that's something that you're wanting to do, but even that would still need to be memorialized in your writing. The lease term with start and end dates, and then finally the signatures of both the landlord and the tenant. So the lease length can be variable. It just depends on what your needs are and the tenant's needs. So the short-term leases are usually 1 to 3 years, and there are different advantages and disadvantages to short-term leases and to long-term leases. So we'll talk about those in a minute as well. Short-term leases, the advantages, they can provide flexibility to the landowner in the way the land is used, so the landowner is not tied in to using it in one particular way for a long period. It gives the farmer tenant the opportunity to experiment with new enterprises or farm locations. So they can move around and try different places, different communities, without requiring any long-term commitments. Short-term leases allow the farmer to test whether his or her farm plans are financially feasible in a shorter trial period that involves less financial risk, and can allow the landlord and tenant to get to know each other before deciding whether they would like to enter into a longer-term lease. Some disadvantages. There's less incentive for the farmer tenant to invest in sustainable practices that pay off over a longer period, such as planting cover crops and perennials. And it can be difficult for both the landowner and the farmer to make long-term business plans when the landowner is not assured of a revenue stream and the farmer is uncertain of having land to farm. So there's pros and cons to both. I just want to take a moment to ask, can everybody hear me okay and everything is working with that? I'll let Eric let me know if anyone's having any problems, but all right, perfect. Looks like everything's coming in on the chat. Great. All right, so we'll keep going. Long-term leases, some of the advantages of long-term leases, they provide more tenure security, and they allow the tenant to invest in the longer-term conservation practices that can help improve the health of the land. They also allow the farmer-tenant time to build beneficial personal and business relationships within the surrounding community. as well as time to become familiar with the particular piece of land that they're farming. Some disadvantages of long-term leases. They provide less flexibility for the landowner in terms of choosing how the land will be used. So they're tied in for a longer period with one particular tenant, as well as for farmers who are still trying to figure out what they want their farm business to look like. If they were hoping to be able to have the flexibility to move around a little bit, then they'd be tied in. So it's important to check whether your state's laws actually limit the length of agricultural leases. For example, in Minnesota, agricultural leases cannot be longer than 21 years, and in Wisconsin, they can't be longer than 15 years. So the length of the lease you choose will just depend on each party's goals and needs. So that will just be something that will come up in discussions between the landowner and the tenant. Rolling leases are something, so they have the term rolled over each year. It means they automatically renew themselves. For example, a rolling 3-year lease renews itself for 3 years at the end of each year, so giving the tenant a longer-term commitment to the land. So the tenant is always assured that they will have at least another 3 years before the lease term is up. Under this arrangement, the landowner would need to give advance notice to the tenant that he or she wants the lease to terminate at the end of the time remaining in the lease. So once the landlord gives notice, then the tenant would have 3 years to get everything wrapped up, under my example anyways. So a lease term of 3 or more years is generally best for encouraging sustainable practices. As the longer lease is, it means the greater a stake that the tenant has in the land. It takes time to see the financial benefit of any investment in conservation practices, just as it takes time to reap the benefits of improved soil health. Farm tenants who use sustainable practices add value to the land, which benefits both the landowner and the farmer. Now we'll talk a little bit about some of the different payment options that can be used. So the most traditional payment option is just a cash lease. It's an agreed amount that's paid regardless of the success of the operation. It's often split, so some would be paid at the beginning of the lease, and then the remainder would be at the end of the season or partway through the season. The amount of cash rent can be based on many different factors. So some of the different factors would be the market rental rates. To find this out, you would ask around among local farmers and county or state extension agents to see what farms with comparable land are rented for in your area. Another factor would be the USDA county average rental rate. So for that, you could check the National Agricultural Statistical Service to see if they have data available on the cash rental amounts in your county for comparison. Also the location. Some tenants who live in bigger cities are willing to pay more for farmland that is close enough to allow them to commute to the farmland, as well as other different location factors. So just take that into consideration. The soil quality. So you would check with the Natural Resources Conservation Service on this one to get a copy of your county's soil survey. So that would help you get a sense of the land's soil properties and capabilities. And sometimes they're divided into sort of prime agricultural land, and you can get a sense if you can charge a premium for that. Also, what else comes with the land? So, for example, irrigation, different kinds of equipment for tilling, et cetera. These improvements can also be factored into the cost. And finally, the personal needs and goals. So some landowners are willing to accept a rental rate that's lower than the average amount. It's sort of in furtherance of their personal beliefs in causes such as the importance of providing opportunities to help beginning farmers, or for their commitment to the local food movements or anything like that. So sometimes landowners are willing to sort of give a break on the rental rate to accommodate that. So advantages of cash leases include that it's a very straightforward and a simple option for landowners who don't want to be very involved with the farming operation. They just want to have the revenue stream. And also the tenant would have more autonomy to make decisions about the farm. Disadvantages include that the landowner can't really consider the rental income as earned income for purposes of Social Security and is not actively engaged in farming for the purpose of federal farm programs. We'll talk a little bit more about that in a moment because that can get kind of tricky, but just know that up front here. And from the tenant's perspective, the tenant bears all the risk, but also does not have to share the profits. So it's just sort of more straightforward, clean cut for each, the landowner and the tenant. Already talked about that. So here's some of the factors for determining the cash rent amount. Let's leave that up for a minute so you guys can see that again. All right, and then here are some cash payment options to encourage sustainable practices. So one would be a graduated rent, which would be just a lower initial rent. It accounts for the extra cost of sustainable practices and operating improvements, and also accounts for possible reductions in yield, especially in the first years as a farmer is learning. So as the farmer learns and improves, then the yields would improve and the rent would rise along with that. So there's a sample provision on this slide here that just shows you how that might work. So it's just an example, but that says that the total rental amount for the first year would be reduced by 20%, for the second year by 15%, for the third year by 10%, for the fourth year by 5%, and then the full rental amount would be charged for the fifth year and beyond. So it's just sort of a way to ease a new farmer into paying the full rental amount and help them kind of give them a break when they're just getting started. So a crop share lease is another option. Under this arrangement, the landlord and the tenant share the contributions and the risks. The rent can be calculated to take into account the landlord's contributions to the operation, which can include equipment, improvements, and even labor or management if a landlord and tenant agree that they want the landlord to be that involved. The rent can be paid as a specified share of the crop, so taking the farm yield and the market price into account. The lease should specify whether the landlord or the tenant would be responsible for selling the crops or the livestock. Sometimes the landlord doesn't want to bother with that, and sometimes they want to be involved. So it just is really up to the landowner to figure out what they would like that term to say. Sometimes the landowner and the tenant will split both the costs and the profits. The proportion that each is entitled to should be written clearly into the lease so that everybody has the same expectations about that. So, as we talked about, or I touched on a little bit earlier, one thing to note here is the impact on certain programs. Landowners who materially participate in the production or management of the farming operation, they need to include the rental income in their earnings that are subject to self-employment tax, because the landowner is viewed as self-employed as part owner of the farm operation, which makes sense because they would be more involved and not just a passive landlord. So the IRS has several tests that it uses to determine whether a landowner has materially participated in the production of agriculture. These tests relate to things like how much of a role the landowner has had in decision-making and management, and also how much labor or money the landowner has invested in the operation. That's just oversimplifying the tests a little bit. Of course, the IRS tests are very detailed, but that's generally what they consider in those tests. Having rental income included or not included in earnings subject to self-employment tax can also impact Social Security benefits. So if you're in the situation, you should be sure to consult with an accountant or contact the Social Security Administration about that. If the landowner is also, quote, actively engaged in farming, which is also defined a certain way, then a crop share tenant is required to share direct and countercyclical payments with the landowner. So the advantages of a crop share lease include that rental income can be subject to self-employment tax and considered earned income that can increase the amount of the landowner's Social Security retirement benefits, and the farmer landlord can share in federal farm program payments. From the tenant's perspective, advantages are that they can often provide an opportunity to learn from a more experienced farmer, and the tenant has someone to share the costs and the risks with. Disadvantages then on the flip side would include that the income for the landowner would be variable and that the tenant loses some of their autonomy because the landowner is involved with the management decisions of the operation. So another option here would be a flexible cash and crop share lease option. So it's sort of a hybrid of the cash and crop share models. The parties agree on a base rent that is less than the straight cash lease, so it's a bit of a break with that. But then on top of that, the landowner would receive a portion of the proceeds from sales. So you can see how it's a bit of a hybrid there. In good years, both of the parties would benefit. In bad years, the landowner is still able to receive a base rent, so they're guaranteed to have that base rent no matter what. And then if it's a good year, then they will be able to have that reward. The additional rent can be based on things like farm yields, crop prices, or revenues. It's just whatever the parties choose. Again, one thing to note, the impact on USDA farm program payments if their payments are based on actual yield. So the federal farm program payments need to be allocated in the same ratio that the crop is divided. If the lease does not comply with this regulation, then the landowner and the tenant may be required to actually pay back any of the federal farm program payments received. So that's an important one to keep in mind. If the additional rent is based on crop price, the market date that will be used to determine that crop price should be specified. Often it's just simpler and safer to base it on overall revenues. So no matter what arrangement the landowner and the tenant agree on, it's extremely important to put it in writing. Be as specific as possible with the calculations, percentages, and the process that will be used to calculate the rent. All right. So next we'll talk about managing risk through insurance. A standard homeowner's policy usually does not include activities related to commercial farming, so that's a very important thing to keep in mind. So that's why it's essential for the landowner to address how insurance will be handled with the tenant. There are different options for the landowner. The landowner can, first of all, ask the tenant to show a certificate of insurance from a farm insurance agent that names the landowner as an additional insured on the tenant's farm liability insurance policy. This should include the location and a description of the property that will be covered by the policy. So by being named as an additional insured directly on the policy, the landowner has the added benefit of being notified by the insurance company if the tenant fails to pay the premiums or the insurance is terminated for any reason. So then the landowner won't be surprised by that. Another option for the landowner would be to add incidental farm and animal liability endorsement to the standard homeowner's policy. This is generally the least expensive option, but it may not be available from every insurer, and it may not address all of the landowner's liability coverage needs. If you want to pursue this option, though, be sure to check with your insurance agent about the specifics and make sure that you understand exactly what is and is not covered. Another option would be to replace the homeowner's insurance policy with the landowner's own farm liability policy. So this one makes the most sense if the landowner is partnering with the tenant in the farm operations and could actually be considered to be a farmer. Another option would be to keep the homeowner's policy and then add a commercial liability policy that covers the lessor's risk. It's also known as landlord liability insurance. If leasing the property to a farm tenant causes a significant increase in the landowner's insurance costs, this is a factor that can be used in negotiating the rental amount of the property as well. Another thing to consider is environmental laws. So the lease agreement should clearly state that the tenants are responsible for complying with all federal, state, and local environmental regulations. However, the ultimate responsibility is with the landowner for staying in compliance with these laws. So it's extremely important that the landowner effectively communicates expectations to the tenant and makes sure that the tenant is actually following the regulations. So the landlord needs to keep up with the tenant and make sure that this is happening. Pesticide application is one area of particular importance for those who are interested in sustainable practices. So it's best to discuss expectations about what is allowed in terms of pesticide application up front, and then include them in the lease. Another consideration is zoning. So zoning is governed by local ordinances. Permits may be required for things such as new structures, greenhouses, housing, and farm stands. The lease can specify who is ultimately responsible for checking into zoning restrictions, but it's a good idea for both the landlord and the tenant to have an understanding of what the local zoning ordinances do and do not allow. So one way that you can use rent to encourage sustainable practices, you could do a one-time rent reduction, which is a simple enough sample provision up here. The first annual rental amount shall be reduced by, and then whatever amount you choose. So that's one way to just give a short-term break to the tenant on the rental amount. Also, you could do a reduction to reward specific practices. So if there's something in particular that you want the tenant to be doing in terms of conservation practices, you can use a provision like this. So for example, the agreed rental amount shall be reduced by 20% for cropland acres in transition certified organic status, and the agreed rental amount shall be reduced by 25% for certified organic cropland acres. So that's one way that you can reward your tenant for engaging in practices that fit with your beliefs. Other ways to encourage sustainability, you can provide for reimbursements or cost sharing for structural improvements. So normally any improvements that are made by the tenant become the property of the landowner when the lease terminates, unless the landowner and the tenant have agreed otherwise. A provision requiring the landowner to reimburse the tenant for improvements that were approved by the landowner protects the tenant against the loss of capital and effort, and can also make the tenant more motivated to invest in the land and structures on the farm. The lease should be very clear that prior approval from the landowner is required if the tenant wants to be reimbursed for any improvements. The lease should also require that the terms of each proposed improvement be put into writing, including which improvements are needed, the costs of implementing these improvements, and how much each of the parties is going to contribute. So obviously it's very important that the landowner and the tenant communicate in advance about these planned improvements, so that the landowner is not stuck with something that they didn't approve, and then there's a fight over who's going to pay for what. Best to get prior approval in writing about all of these things. Another option for encouraging sustainability would be to just share in the costs of sustainability practices. So, for example, a landowner can do things like provide credit toward the rent for a tenant's expenses on sustainable practices, such as crop rotations or application of green manure crops that improve the soil beyond the term of the lease. Encouraging sustainability from farm tenants requires ongoing communication between the landowner and the tenant. Different reports on the farm operations, such as those required for maintaining organic certification, OSPs or organic system plans, or other reports for federal farm programs, those can be used to facilitate discussions between the landowner and the tenant and to make sure that everyone's on the same page. Also, obviously, calls, emails, and letters should be used frequently to keep the lines of communication open. So that was all about encouraging sustainability. These are ways that you can require sustainability if that's what you choose. So one of the easiest ways to make sure that conservation practices are used on your land is to incorporate a conservation plan from the Natural Resources Conservation Service into the lease. The landowner, the tenant, and the NRCS staff can develop plans together to make sure that they are feasible and also accommodate everybody's goals. Threshold and monitoring provisions can also be included in the lease. One example of that would be acceptable levels of soil erosion. It's important for the lease to spell out who will be paying for the monitoring and also how it will be happening. If it will be the tenant, then this cost should be factored into the rent calculation. If land is already enrolled in a conservation or preservation program, just be sure to include in the lease the requirement that the tenant needs to comply with all the requirements of that program, because the landlord will ultimately be responsible still for that. So just make sure that the tenant knows what their expectations are for that. Some other lease options that are available. There's a ground lease. They are not very common, but they allow for the tenant to own the non-removable improvements on the land, such as a house, a barn, or fencing, but then they actually rent the land itself. At the end of the lease term, the tenant can sell the improvements to the next tenant or back to the landlord, which allows the tenant to recover his or her equity on those improvements. Because ground leases involve both selling and leasing property, they can be pretty complex. So if you want to do a ground lease, just make sure that you consult an experienced attorney and make sure that you have all your bases covered on that. Ground leases can allow tenants to build equity over time, which is one advantage of those. An option to buy or a right of first refusal is another option for leases here. You can put in a provision about this. This provision in a lease provides the tenant the opportunity to purchase a property after a specified period. With an option to buy, the tenant can generally purchase the property at a fixed or determinable price at any point during the lease. With a right of first refusal, the landowner is prevented from selling the property to a third party without first giving the tenant the opportunity to make the purchase, normally for the same price that was offered by the third party. Another option would be a contract for deed. It's a little bit different here, so it fits with the leasing, but it's not part of a lease. So it's just sort of a side note here. Contracts for deed are a way for somebody to purchase a piece of land without going through the whole mortgage process. So in this case, the seller keeps the legal title until the contract is paid in full. The advantages include that it would be quicker and simpler than a mortgage. It can provide a financing option for those who don't qualify for a mortgage. There can be lower down payments and interest rates, and also no mortgage origination fees. And there's also a tax advantage for sellers because the income from the land is spread out over time rather than coming in one lump sum, as it would for sales made in a mortgage loan. So some disadvantages. The buyers actually risk losing all the money paid in, all of their equity, if a contract for deed is canceled. So if these payments had been made in the form of mortgage payments to a lender, the buyer might actually be able to recover the value of the equity if the buyer is able to sell all or part of the property before a mortgage foreclosure occurs, or if the lender is able to sell the property for more than what is owed at a foreclosure sale. So with a mortgage, there's at least the opportunity to be able to save that equity, but with the contract for deed, the equity would just be lost. For buyers, another disadvantage would be that it can be canceled more quickly than a mortgage can be foreclosed. So there are statutory protections given to mortgage purchasers that are not available for people under contract for deed. Also, a disadvantage for sellers, it requires an ongoing responsibility from the seller for the full term of the contract for deed. The seller is responsible for taking action if the buyer doesn't make payments or defaults in some other way. So other lease issues to consider. So you'd want to talk about termination. Make sure that the lease clearly states the manner and time in which either party must give notice if they want to terminate the lease. And make sure that these notice of termination procedures comply with the laws of your state, because that is often something that is controlled by state statute. Also, the consequences of landowner bankruptcy. Generally, tenants can stay until the end of the lease term, but they may have to assert their rights and then pay rent to a new owner. The best case scenario, as with everything, is to be clear in the lease about what will happen in this situation. And then the consequences of tenant bankruptcy. The landowner can normally get a priority lien for the money that's owed, but generally has to perfect his or her interest by submitting the lease to the public record for the county. That puts other creditors on notice. that the landlord has a priority lien. Another thing that can be addressed in the lease would be subletting. The lease can specify whether the tenant will be allowed to sublet the property and also under what conditions. Subletting typically is not allowed under farm leases because landowners prefer to have control over who will be farming their land. However, the parties are free to negotiate that term as they wish. Default is another thing that should be discussed in the lease. Should specify what actions will be considered a default of the lease agreement, such as the failure to pay rent, also the failure to maintain the necessary insurance, or the failure to comply with state and local laws. The lease should also provide cure periods for defaults that are able to be remedied. So, for example, if a tenant is late on the rent, providing a certain amount of time, for example, 30 days, that the tenant can then submit the late rental payment and cure the default. As I see Eric said in the chat box over here, if you have any questions, feel free to ask along the way. We're actually sort of cruising through our information here. So if you have any questions, we've definitely got time. So in review, then, you want to analyze and negotiate. Make sure that you understand and that you have read the entire lease. You'll want to use a checklist to check for different danger zones and make sure that you've considered everything. So then decide what you need to change and either cross out or write in the terms and negotiate. So theoretically, everything is negotiable. Don't feel pressured to accept all the boilerplate terms, even if somebody says that that's how they always do it. You don't need to feel pressured to just accept that. Make sure that you get all of the changes, especially verbal changes. Make sure that you get those written down. Legal counsel, as an attorney, I'm obliged to say this. Legal counsel is worthwhile to help review the lease and, if necessary, to negotiate more favorable terms. Sample or template leases are actually a great place to start. So getting that start can save you time and money when you bring it to an attorney. And then it can also help you to start thinking about and organizing your priorities in advance so that you have a good idea of what you want to include in the lease and talk with the attorney about. All right, so as I talked about earlier, here's a list of helpful farm lease resources. All of these places have just an amazing wealth of resources on here. So if you are looking for more information on any of the non-legal topics that we talked about, then this is a great place to start. And FLAG is also available to help with things like reviewing leases. So if you get to the point where you have a lease that's prepared and you want to have somebody take a look, usually we have guidelines in terms of income restrictions and things like that, but you can get in touch with us and we will see if we can take a look at it for you. All right, and then as Karen mentioned at the very beginning, there's the Farm Transitions Toolkit can be found at the landstewardshipproject.org website that's up there. And then also all of these other places have many different sample leases and publications that go into these things. So I see on here that somebody's asking if this page can be sent to the participants. I think I'll have to figure out how to do that in terms of sending out an email to everybody, but I will definitely look into that. And I think that should be a possibility. If not, then this whole webinar will be recorded and put on our website so you can access that again later. All right, so this is way early, but that's actually all I had prepared to talk about. If anybody has any questions and answers that they'd like to do at the last half hour here, then please feel free to send over your questions. I think the best way to do it would be to write them in the chat box, and then Eric will read them out loud. And again, if any of you in the future need any help with any of this stuff, you can definitely give us a call, and we will see what we can do in terms of helping you with your situation and reviewing leases.
So we have a question here from Ryan in Iowa. He's asking, how is a lease affected? How is a lease affected when the landowner passes?
I believe that would be sort of different in every state, but then that's actually another thing that you would want to probably address in the lease. You know, in a perfect world, all of these things would be written into the lease. So that's another thing to consider when you're drafting your lease, to say what will happen in that instance, or like we talked about with the bankruptcy or something like that, when there is a new owner of the property. It's best to talk about that up front, and I know it's not always pleasant to talk about those things at the very beginning, and sometimes that slips through the cracks. But ideally, it's best to just come to an agreement on what will happen with that, and whether you want to have the lease transferred to a new owner for the remainder of the term, or whether you want that to actually cancel the lease when the landowner passes.
All right, we have another question from Mike. Are there any things that you have seen in leases that are huge red flags?
I mean, I guess it's hard to say specifically, but things that would be very one-sided. Like if the landowner would be sort of trying to put a boilerplate form onto a tenant, trying to push them into something that they say that you just have to agree to all of these terms because this is how I always do it. Those can sometimes be very, very one-sided and kind of exploitative. So that's why it's so important to make sure that you read everything. And if you take issue with one of these boilerplate terms that's in there, just make sure that you actually take the time to negotiate and try to get that changed. It's not always going to work, but if you get a sense that it's going to be a very bad situation and it's not something that you're comfortable with committing to, then it might just be a situation where you want to actually just walk away from it and not agree to lease that land because you don't want to be bullied into something that you don't want to be committed to. So just know that may be what ultimately ends up happening.
Right, there's another question here from Nina. Do you have any more links for ground leases?
Let's see. I will look into that, and I will get back to if we can write down Nina's name, and then I have your email address from your registration. So I will look into getting that for you afterward. And if anybody else is interested, feel free to let me know as well.
All right, another question is from Ryan. Does the lease continue with the spouse? I'm assuming that's in the event of a landowner passing.
Right. Again, I think that you could specify what you would like to happen in that situation in the lease, but I think normally, I would have to check into that to be certain, but I think normally it would probably continue with the spouse because they would be generally, in most cases, I would think that the spouse would also be a part owner of the land, and so that would probably just continue with them. I guess it would be a different situation if one spouse owns the land and the other one is not on the deed or anything like that. That could get a little bit more tricky, but I think in most cases the spouse would also be a part owner of the land.
Great. Now we have a question from Sue. When considering a lease, how long does the process take from start to finish?
In terms of like drafting, is that what you're thinking?
Could you clarify for us in the chat? I think that might be in general.
Okay.
From the beginning
pull us up there with that.
Of exploring land to the signing of the lease.
Well, exploring land, that's a whole separate thing. So when you're looking for land...
Sue clarified, it's about drafting a new agreement. How long should that take?
Okay. Drafting a new agreement, I think, it doesn't have to take a very long time, particularly if you start with one of these sample leases where they really have a lot of the things that you want to consider laid out for you, and then you can just sort of go through and plug in terms that work for you. So if you want to get a sample lease ready to go and write out, kind of a preliminary draft and bring that to an attorney to have them review, that should save you a lot of attorney time because it shouldn't be too burdensome to do that. But I think the place where it would probably end up taking more time would be the actual discussions, the negotiations between the landowner and the tenant, because you really want to make sure that everybody is in agreement on everything. So that can actually take some time, but it's well worth the time to just sit down and make sure that you have good communication about that and really work through all of these terms, even though it can seem kind of burdensome, like there's just way too much to consider. But it's worth it in the end. And then once you have a good lease in place, then you can sort of just keep that going forward, particularly if you've got the same tenant, you can just keep renewing that lease. So it's good to get a great lease in place from the very beginning.
Great. Now, Judith's question is next. She asks, can you discuss how you might specify labor, like cutting down volunteer trees, exchanged for land use in a lease? Some examples of just how labor could be exchanged for land use in a lease.
Okay. Well, I think, just really what you would do is specify what your what activities you're going to have the landowner or the tenant do. I guess you're asking probably for the tenant in exchange for rent. So just valuing the service would be the big part there. I think that the landowner and the tenant need to sit down and just talk about how much it's worth to the landowner to have the tenant perform those different services for them, really placing a value on that. And then you just need to memorialize everything you talk about in the lease, talking about the value, time per hour and that kind of a thing, whether that's going to be an expectation of, X amount, a chunk will be cut off of the rent, or if it's going to be like an hourly thing that will be credited toward the rent. There's a lot of flexibility when you're drafting these things, but just make sure that whatever you discuss, that you write it down and that you're both in agreement about what it's going to entail.
Right, our next question then is from Mike. He asks, for vegetable producers, do you have any suggestions for ways to deal with the cost of a new well with sufficient capacity for irrigation? So about 100 gallons a minute.
For vegetable producers, meaning from the landowners or the tenant's perspective, I guess is what I'm wondering with that. But
Mike, could you clarify for us in the chat? From the tenant's perspective.
Okay. So from the tenant's perspective, suggestions for ways to deal with the cost of a new well, sufficient capacity for irrigation. So I guess if you're wanting to have the landowner, or if you're wanting to install a new well, is that probably what you're asking about? So it would be one of those structural improvements. Okay, cost of improvements.
Yep.
It's one of those structural improvements that we talked about a little bit earlier. So it's just, again, you need to sit down with the landowner and really talk about if that's something that they're interested in having you install on the property. If it's something that they're interested in because it would add value to their land, then you can sit down and talk with them about whether they want to do a cost-sharing kind of a thing or whether they would reimburse you for that, the costs of putting that in. So because it would ultimately stay with the land with them. I guess there are some ways where you could do it where you as a tenant would actually still own that piece of property in terms of the actual well and the improvement that you installed. But then that kind of creates a whole different hassle with having to remove that improvement to take it along with you at the end, and might be more trouble and cost than it's worth. But that option does exist. but it's probably better to just sit down with the landowner and see if you can come to an agreement about sharing the costs or getting reimbursed for it, since it will be sort of, for the most part, staying with their land and improving their land costs.
All the questions we've gotten so far. If other people have more questions, feel free to put those in the chat and we'll get those answered for you. As a reminder, this entire recording will be up at www.flaginc.org in the coming days, so you can always go back and look at your favorite parts, check on some questions, look at that resource page, or share it with other people who you think it could be beneficial to. Jake has a question here. Any experience or specific issues you have seen with the tenant living on the land?
Yes, so that actually creates a whole different set of issues there. I think there are different options, as with everything, that you can do with that, but I think normally it would be best to have a residential lease separate from the commercial farming lease. And oftentimes that is something that tenants are really looking for, is to have housing that is directly on the farm. So you can usually factor that into the rent, because that's something that would be very valuable for the farmer. But if you're leasing the home to them, then that sort of brings in all these different residential lease statutes and protections for the renter. So you'd have to make sure that you keep the premises habitable, and all sorts of things like that come along with being a residential landlord. So it's best usually, and the least complicated, to keep those separate if you just have a residential lease for the house part and then a farm lease for the remainder. And actually, I think that is discussed in one of the resources that I included. I'll just go back to that screen because that was probably the most helpful. So I think it is this one towards the bottom here, the Land for Good website. They have something called the Landowner's Guide to Leasing Land for Farming, and that has a lot of great information about all of these topics. And I know that they specifically discuss the tenant living on the land in that guide. So if you want to check that out, that would probably be pretty helpful.
No other questions right now.
All right. Does anybody else have any questions they want to put in the chat box?
Here's one from Paul. If a landlord wishes to have no soybeans planted on HEL land, how would she best go about it? Maybe that was her land. How would she best go about it?
So I think that would just be another thing that you can incorporate into the lease about, you don't want to have the traditional, like the row crop farmers on your land. I mean, then that would also go along with just finding the right tenant. Obviously, if you want to have somebody that is more of a vegetable producer or a livestock producer, that you just have to find the right person who has values that align with yours. But that can be put into the lease that you don't want to have them planting row crops and things like that on the land. But again, that would just arise from discussions between the landowner and the tenant.
HEL equals highly erodible land. My mistake, everyone.
So that's also something then you could work with, like we discussed a little bit earlier, the NRCS. So if you can work with them and the tenant and the landowner all together, you can go to the NRCS office and come up with a conservation plan, so where they would sort of take a look at the actual piece of land and figure out which areas are highly erodible, and then help you come up with a plan that can be incorporated into the lease that gets very specific about what can be planted where, things like that. So that's probably the most specific way to incorporate that into the lease. I see another question here from Jeanette about FLAG having a referral service for finding legal counsel. We do have a referral database here, so if you ever are looking for legal counsel in your state, feel free to contact us and we will check our database. And then even if we don't have somebody that's in our referral database, we generally know different people involved in agriculture and different farm advocates throughout the country, so we can usually find somebody that can help you out with your legal needs.
There's a question from Judith. You mentioned having someone do monitoring for erosion, etc. Who does one contact to do that? Is it a service that you hire?
I don't know a whole lot about the exact specifics about that. What I have seen in some of my research was just, you could choose to have somebody who's more experienced with that in terms of, like, if you've got a neighbor who's done a lot of soil erosion monitoring, things like that, you could maybe enlist them to help. Otherwise, I think NRCS would probably be a great place to start with that. Even if they can't actually help you with the monitoring, they would certainly have a database of resources that they could probably direct you to. So I think NRCS is usually a great place to start for soil and conservation issues.
Paul has a question. Is there a requirement in MN for mediation on leasehold issues that are in dispute?
I would have to check in particular to be able to say for sure, but if there are, I suspect they probably, I think there's something to do with the farm mediation, but I don't want to misspeak here. So I would have to look into that and get back to you. And like I said earlier, I have your all of your contact information from the registration, so I can get in touch with you about this after the fact, if that would be helpful.
Nina has a question. Are there any more grants in the works to help draft new agreements, then add them to the toolbox?
In terms of the toolbox, I think we'd have to ask Karen if there's anything else going on with that right now, because I'm not entirely sure. But FLAG always has different grants in the works that are going to be helping with these issues. So I guess I don't know about anything in particular, but I can say that that's usually going on. Are you guys still working on any more pieces of this, Karen?
Actually,
yep,
yes.
You're unmuted.
Okay. Yeah. So we are continuing our work with Legal Action Group, which has been great, and trying to more common issues that people might face. And one of the things that I wanted to lift up and share is that we're trying to share stories of and even things that haven't gone well, and so that we can help people avoid issues in the future. And so so that is happening right now, and it may at some point come through the toolkit or maybe sent out in other publications, that kind of thing. But so we are starting to do that. And I also wanted to lift up, if any of you have stories that either you know of or are your own personal stories that you'd be interested in talking with me about, I would be very interested in doing that. And certainly you can get on our website and see in the toolkit some of the farm transition profiles that have been done as kind of an example of what we're thinking about and trying to lift up. So I should just ask if people were able to hear that. I'm sorry, it sounds like very clear.
Yeah, I think it's cutting in and out a little bit.
Yes, we're looking at other.
I think you're gone, Karen. Sounds like we lost Karen. If you can hear me, Karen, maybe you can just type an answer into the chat box, and that will go out to everybody. All right, well, if nobody else has any other questions, then maybe we should just go ahead and wrap up. Yes, last call for questions here. I'll just put up my contact info again quickly here. So this is my email address. My name is Jennifer Kalyuzhny again. You can give us a call or send me an email anytime when you've got questions about these issues, and we will get back to you as soon as we can. Also, there's Susan Stokes is the executive director of our organization. She also works on leasing issues, so you can also contact her. All right. Well, thank you, everybody, for coming tonight, and it was my pleasure to be able to present this information. Please do follow up and let me know if you have any other questions in the future, and I will try to get back to you as soon as I can. So thank you all for taking the time to attend on a Wednesday night. I appreciate it. Have a good night.